Okay, so pages 1 through 22, which is case 831-543, Hunwardsen versus Affinity Lifestyles et al. So let's go through who we have for the various parties here on that case. On behalf of plaintiff, who do we have, please?
Good morning, Your Honor. Eric Pepperman for Plaintiffs.
Are you the only one at your firm that doesn't have an outstanding pro bono case? Usually everyone at your firm does. That's why I'm surprised. But no worries. I'm not putting you on the spot too much.
Oh, we have pro bono
Personally.
cases.
You
I
personally.
personally have a pro bono case.
That's what I was asking. If anyone had an outstanding pro bono case, I'd take your case first.
Oh, I thought you meant pro bono case here before you.
Oh, no, it counts anywhere. If you have any outstanding pro bono case, we're just encouraging pro bono cases. So I just know your firm has usually lots of them.
We do. We have several.
Win awards on that. So that's why I was surprised when I kept saying it. Nobody said anything, but no worries.
I misunderstood that.
No
Next
worries.
time I'll know.
Well, you get to go first anyway. So let's go. So I heard your beginning of your name, but did you say your various clients, or are you doing all plaintiffs?
Eric Pepperman for the plaintiffs in this Hunwardsen case. And if it is easier for the court to call all the real water cases at once, I think that makes sense because they're really the same issue in each one.
Well, I'm going to have to see if everybody wishes them to argue in any consolidated matter to be taken for each of the cases, and then we set forth it for each case, or if we need to do it for each case by case, because it doesn't matter from your end. So let me hear what everybody else wants to do, and then, of course, can be fine either way. So let's get some more appearances, please.
Good morning, Your Honor. Brian Flanagan for Hanna Instruments, and I'm okay with consolidating cases for this purpose.
Good morning, Your Honor. Howard Russell for Costco, and also fine consolidating.
Okay. I just was, without double checking each of these, some of these have some different parties in them. So let's see. Who else do we have in Hunwardsen?
Good morning, Your Honor. Joel Odou on behalf of the real water entities. In all the cases, our remote appearance was filed on February 24th. We have no objection to them all being consolidated, and we have no opposition to any of the motions before the court today.
Appreciate it, and thanks for that general heads up on all of it. Who else do we have remotely, please?
Sorry, Scott Cook, 5265 for Speedy.
We could not hear you. You kind of spoke quickly with your hand over your mouth. We couldn't really hear you. Could you mind appreciate
It keeps it secret. No, Scott Cook, 5265 on behalf of Speedy Mart, here for the amendment of the Second Amendment complaint and no objection.
Okay, what I need to confirm is, are you on all 4 cases or only some of those cases? Because you've not previously appeared on some of them. That's why I was just making sure.
No, in fact, we haven't appeared. All we have done is add ourselves to the mailing. At this point, we have not filed a responsive pleading. Okay,
and that's why the court was asking. So, are you just observing at this juncture?
I'm on the Caveh case, is where I will be entering an appearance. Kaveh.
Okay, but at this present moment, are you on any case? Have you filed any notice of appearance?
I have not.
Okay, so for today's purposes, are you saying that you wish this to be viewed as your initial appearance, even though you haven't filed them and I have to check with everybody else? Or are you just observing for purposes?
No, this can be my initial appearance. We will be entering it. We're on an extension of time till everything gets sorted out.
Okay. Are you planning on saying anything, sir?
No.
Okay, the reason why is because I'd have to circle around with everybody else because there's not an official notice of appearance. Okay, but if you're just, okay. And you're only on base and you're not speaking, so that's not an issue. Okay, let's go to anybody else. Who else do we have, please?
Good morning, Your Honor. Michael Melendez on behalf of ETT1 LLC, doing business as Terrible Herbs. We are in the Hunwardsen case, and we have no objection to consolidating the issues that are going to be resolved today.
Okay, you're in Hunwardsen only, or you're in what other? Because without me cross-checking all of them, I could go through and cross-check them all, but it's easier if I ask counsel because you all know which ones you're in.
Certainly, Your Honor. Only in Hunwardsen.
Okay, that's what I thought. Okay, so make sure. Okay, who else needs to make an appearance, please?
This is David Spurlock appearing on behalf of United Whole Foods on Hunwardsen and Henry, bar number 2565.
And the date of your remote appearance, Mr. Spurlock? Or on what pleading it was placed on?
It's a remote appearance.
Sir, I understand it's a remote appearance because you're not physically here in court. What I was asking is, under the Supreme Court rule, right, and the administrative order, as judicially reminded of all parties, not only in the memorandum you got today, but every other memorandum that's been sent, did you file a notice of remote appearance? And if so, similar to what Mr. Odou said, he said the date that he filed his notice of remote appearance, right? I didn't have to ask.
I
Mr.
believe
Cook
we did
because
file
he's not-
a notice of remote appearance.
And what date would that be, sir? Because you know the court did not approve any remote appearances that were not audio-visual, just like this court doesn't do it in other multi-party cases because it's way too complicated. As you can tell, you pretty much have whether you want to call it a Hollywood Squares, you want to call it a Partridge Family, right, series of blocks, then it's too difficult to have an understanding of who may be trying to speak when we don't even see the person. So it's only audio-visual only, and that's clearly on our memoranda. But can you give me the date that you filed your notice of remote appearance, please, sir?
I'm having my paralegal pull it out now. Your Honor, if it's more convenient to the court, I can be for observation purposes only.
It's not a matter of what's convenient to court. It's just whether or not you wish to make an appearance. You're more than welcome to make an appearance. If you're going to make a remote appearance, then, of course, the court has to follow Supreme Court rule and administrative order. If you're just observing, then the rules are a little bit different. I just need to know what each individual wishes to do. The court's fine with whatever, as long as it follows the appropriate rules. Thank you so much. So which is it, please?
They're pulling out the remote appearance, a audiovisual notice now, Your Honor, but for the court's convenience, I'll do for observation purposes only so the court can move forward.
Okay, so you're not planning on speaking, Mr. Spurlock, is that correct?
That's correct, Your Honor. Thank you.
Okay, if it's just an observation, then we'll just move on. Okay, who else would like to make an appearance, please?
Good morning, Your Honor. Melissa Roots for 7-Eleven Inc. We filed our notice February 27th, and we're only in the Henry matter.
Okay, in your view, if I handle these in a consolidated aspect?
Correct, no objection.
Okay, thank you so much. Anybody else want to make an appearance, please? Okay, last call. There's nobody else who's walked into court. So for those who,
Your Honor, Lorraine Christopher Katie, Distributors of Nevada, in the Henry matter only.
okay, were you able to hear her? Okay, sure. Sorry, I just want to make sure you're close enough to the microphone that we can hear you. And your position with regards to hearing these in a...
I have no objection.
Okay, so thank you very much. For those of you here in court, feel free to sit down, stand up. When you argue, you can utilize the podium. You can sit down or stand up at council table. Whatever meets your needs is fine with the court. So let's get to some substance. Substance of the underlying motion. And if it is different with regards to any of the cases, please just indicate in your oral argument. And if you're saying that this is what you wish to apply to all four cases, let the court know. And if it's something less than all four cases, please let the court know so we can get that handled for you. So, excuse me. Let's go first to move it. It is, so we have it clear, it's plaintiffs. In the Hunwardsen matter, it's plaintiff's motion for leave to file third amended complaint on order shortening time is document 225. I have an untimely opposition 232, but I need to see if it truly is untimely or if there was an issue because of a certain thing that happened. Reply, document 234. I'm going to say all four cases, document numbers, just so we have it clear. With regards to the right matter, the plaintiff's motion for leave to file the third amended complaint on order shortening time is document 203. And Hannah's opposition on this one shows as timely, document 208. Then there was an errata filed, which is document 209. And then there was a reply, which is document 211. With regards to Henry, which Henry is page 46, and I should have mentioned Wright was page 23. So Henry is page 46, is case number 844176. Excuse me. And that plaintiff's motion to file third amended complaint on order shortening time is document 153. And the instruments he shows timely on that one, document 160. And reply is 162. And then we go to page 52. And page 52 is plaintiff's motion for leave on this one. It says file second amended complaint on order shortening time rather than third that was in the other ones. And that was document 17. And what was going to check to see if there was an opposition or if there was a reply on that one when we get to that one. So let's walk through counsel for plaintiff. Are you still wishing all four of these to be combined?
Yes, Your Honor, and I can try to summarize the difference between the motions. The main difference is in the Cavey case was only recently filed, and we amended to add the Hanna entities that we seek to amend and to add in the other three cases as a matter of right. Subsequent to that amendment, we learned that one of the Hanna entities we had misnamed. It was a different entity. So to correct the name, we filed the motion to amend in Cava, just to correct that and then drop another claim that there's no dispute to that amendment from anyone. The only dispute as to the other three cases.
Okay, so let me just stop you for a quick second on Cava, make sure everyone's on that same page. Is that correct? Because I did not see any opposition. I did not see any further motion practice other than, like I said, the motion for leave. Is that correct, counsel, for Hanna?
That is correct, Your Honor.
Okay, so then that one, let's just clean this one up before we get to the next three, right? So that would be page 52 for plaintiff's motion for leave to file second amended complaint on order shortening time, document 17. Court is going to grant that pursuant to EDCR 2.20, there being no opposition, and the court confirming such in open court. So now let's deal with your other three cases. Go ahead, counsel.
Thank you, Your Honor. The other three cases, the amendments that we seek are very generally to add or drop various distributors in the different cases based on discovery to date, and then to drop a claim based on the Nevada Fair Trade Practices Act, and then to add claims against additional entities related to Hanna Instruments. Hanna Instruments designed and manufactured the meter in the real water making process. During discovery that we confirmed in depositions just a mere few weeks before we filed our motions to amend and sought leave to amend to add these parties, we discovered additional information about other Hanna entities that were involved with the design and manufacture and label of the meter at issue in this case. And we've amended to name the parent companies. Hanna Instruments is a global scientific instruments company. It's a very complicated corporate structure, and they all fall under two main parent entities that we allege and believe control everything and are responsible for operating these companies, including the public-facing company, Hanna Instruments, who sold the meter, in this case, in the United States. And so we've added claims against them. Our argument is straightforward. We learned about these additional, the basis for these additional claims. We've amended our complaint within a couple weeks of learning that. We seek it. These types of amendments are freely given as under Nevada's liberal policy of granting leave to amend. The only objection from any of the parties in all the cases, including the ones before you and the ones that aren't before you, who's raised an objection to these amendments, is Hanna Instruments. Their argument as to why they're opposing these motions is that we were somehow dilatory, or that the motions would be futile, or the amendments would be futile. They don't really make any legal argument about futility, about why these claims are not available as a matter of law or fail to state a claim under Nevada law. Really, it's just some argument that we were somehow dilatory, but as we stated in the replies to that opposition, we've been pursuing discovery in this case very diligently. We didn't get the discovery responses identifying the details or the witnesses until the end of December, and that was only after we had to seek a motion to compel from Special Master Hale, who compelled them to produce by that December date. We received the information in the end of December. We scheduled the depositions of the witnesses that were identified. took those depositions on January 25th and 26th, and based on those depositions, we began amending our complaints. It's an arduous process. We amended all of our complaints. There's 12 different complaints to draft motions to amend, conform them. It took a couple weeks. We filed them on order shortening time, and here we are. So I would just say that the sole argument that we were somehow dilatory, it doesn't coincide with the facts, and we would ask that the court, in light of the liberal policy of granting leave to amend, grant these motions. Thank you, Your Honor.
Counsel, would you like to be heard on all three cases? If there's a distinction from your end, let the court know, okay?
There's no distinction, Your Honor. And I agree with counsel. Rule 15 is freely given, but it's not always given. So we laid out law in our opposition and recanter of reasons why that Rule 15 is not given, and some of them are undue delay and dilatory motives. By definition, undue delay is a balancing act. We delay things all the time. We delay trials. We delay motions. Here, counsel's asking for a delay, but offers nothing to balance it against. He cites depositions, but doesn't attach any deposition transcripts. He cites documents in his reply, but doesn't attach any documents. All that we're supposed to rely on is the declaration of Mr. Kemp, which, all due respect, they have the evidence. Why not attach it to the motion to give the court the full picture of why they need to delay these cases? And with that, I rest.
Thank you. Quick question, though. Do you disagree with the timeline stated by plaintiff's counsel that there was pending motions to compel before Special Master Hale, who is the appointed Special Master in this case, and that those documents that are at issue weren't produced until sometime after December 2022?
I saw the reply that attached the Special Master hearing. I wasn't on the case back in December. I don't know the context of what was going on there, but he produced the Special Master order. I agree with that, Your Honor.
And the reason why the court was asking that question, right? If you look at Special Master order in December, and you look motions coming before the court in February on cases that are in 2021 with trials set at agreed upon dates in 2024, I was trying to evaluate that with the delay argument. What could they have done quicker if your client was not providing the documentation, right? And they had to go to the Special Master to get the very documentation which they're saying they're relying on to do these amendments. What could they have done differently when you're saying there's delay?
Well, Your Honor, it being 2 years old, and like I said, I wasn't on the case. I don't really know the context back then, but 2 years, I'm not sure it takes 2 years to compel a 16.1. Maybe it does in this case, but like I said, the original filings being in 2021, and we're here in 2023.
No, and I appreciate you weren't on the case back then, but wouldn't these disclosures have been, as you point out, initial 16.1s, which you affirmatively should have done? They shouldn't have had to go and get relief for that?
It's a fair point, Your Honor.
I'm trying to understand the delay, and that's when I looked at it, I was like, oh, is there a dispute in the chronology? And so I just need that clarification. I do appreciate it. Thank you. Go ahead, counsel. You get last word on behalf of plaintiff.
Your Honor, I think just to clarify on the timeline of the case, we did file in 2021. We were taking steps to get started in discovery when some of the other defendants removed the case to bankruptcy court, where we were for 8 months. We weren't back in state court until April of 2022, at which time Hanna was added. It became added to the cases only while the bankruptcy removal was pending. We served our discovery responses in July 2022. We got insufficient responses in October after multiple requests for extensions from Hanna. We met and conferred, had to ask Special Master Hale to compel the supplemental responses, which he did, ordered in December 2022. We took the depositions based on that information in January 2023, and here we are in February 2023 moving to amend, or we moved to amend in February. I guess it's March already. Thank you.
Before the court makes a ruling, I did not see that anybody else filed any other pleading on this case. Does anyone think that they did? And I appreciate sometimes people have the issue where they have inadvertently filed it in a different case number, because remember, these are only consolidated for coordinated for discovery purposes only. They are not consolidated cases. Does anyone think that they should have an opportunity to speak? If so, please let the court know. Not seeing anybody standing up here in court, and not seeing anyone turn a little green on remotely. Okay, so then the court's going to make its ruling. The court's going to rule that the court is going to grant plaintiff's motion for leave to file a third amended complaint on order shortening time, document 255, in the Hunwardsen case 831543. Court finds you all have stated the correct standard of Rule 15. Leave should be freely granted. Here, realistically, looking at the chronology, the court doesn't see any of the exceptions to it being freely granted. The court does not see undue delay. Do you need me to do it a different way for case numbers?
Was it document 255? 225.
225. Sure. So plaintiff's leave to file third amended complaint on order shortening time, document 225, which was filed on 2/22/2023. So when you look at that chronology as the court was setting forth, the court doesn't see that there's undue delay. And that was the only one really that was cited with regards to any other issues which are a substantive matter. They're not before the court here on a Rule 15 motion. The court's ruling only on Rule 15. And so therefore the court finds it appropriate to grant the motion, document 225, on Hunwardsen, case number 831543. Now going to Wright versus Real Water. Excuse me. That motion for leave to file third amended complaint on order shortening time is document 203, filed on 2/21/2023. And that case is 831880, and Wright is spelled, of course, RICHT. And so the court would find in this case as well, leaves freely granted. The standards of Rule 15, the case law supports it. None of the exceptions apply. The same analysis the court said with regards to Hunwardsen would equally apply here, and that's all set forth in the papers. The chronology is such that realistically, the timing of being able to file this is really as a result of Hanna not providing the documents that potentially would have been required to at 16.1, but at least pursuant to discovery responses, and not in dispute that there was extensions, and then the motion to compel in that time frame. So none of the exceptions apply. Therefore, Rule 15 would control, and that motion is granted. Then going to Henry, which is case 844176, and plaintiff's motion for leave to file a third amended complaint on order shortening time. In that case is document 153, and the court's going to grant that as well. Same analysis, Rule 15, same analysis with regards to none of the exceptions apply, and therefore each of those are granted. Now, for purposes of your orders, however, I am going to need 3 separate orders because these do have separate case numbers, and you can't file an order in 3 separate cases on a joint order. Okay, so I will need 3 separate orders, EDCR 7.21, within the 14 days to the GC31 inbox in accordance with the administrative order. With regards to, just as a heads up for the various parties that I have many of the parties in these cases. It is very helpful to the court, as you heard the court mentioning document numbers when I was referencing these, if in your future pleadings, because to the extent these cases are going to have potentially a number of entries, is kind of following the federal court view, right, where you put like on an opposition, it's an opposition to document number blank. So I will tell you in advance that is helpful because trying to look through all of these can be somewhat cumbersome. It is not a specific requirement. It is telling you that the court's saying it is helpful. If you want to do things that are helpful to the court in reviewing your papers, please do so. If you don't want to do something that's helpful to the court in reviewing your papers, then I'll need to address that as I need to address that. And anyway, that's just a caveat just to everyone for helpfulness. It's helpful for you all as well because that way you're ensuring it's the right case going to the right department and the right one that you are responding to the extent that there's multiple issues going on in different of these coordinated cases. And that was just a follow-up caveat. Is there anything else that the court could do for anyone on Hunwardsen 831543, which was page 1 through 22? Counsel for plaintiff, anything else for you?
No, Your Honor, thank you.
Okay, counsel for Hanna, anything for you?
No, Your Honor.
Globally, for anybody else who's in Hunwardsen, is there anything else that you felt that was on for today that the court can assist with? If so, please feel free to speak. As long as I do give me a negatory nod. Anybody needs anything on that? Nope. Okay, so then we're moving on to page 23. Page 23 to 45, which is the Wright case, 831880. Is there anything else that the court can do on this case, because of course I've done it is so ordered on all three cases, but is there anything else, counsel for plaintiff? Anything else from your end?
No, Your Honor. Thank you.
Not for
No,
now.
Your Honor.
Anybody else who's on the right case need to be heard? Anything? I'm seeing some negatory nods in court. I'm seeing some negatory nods audio-visually. So it does not appear anything's needed there. Then let's go to the Henry case. Henry case, as the court had already made its ruling, it was so ordered on 844-176. Is there anything else from plaintiff on Henry?
No, Your Honor.
Anybody else need anything on Henry? No. Okay, so then we would look, just to make sure, on page 52, Kaveh, Kaveh, which was 864391. Is there anything else needed on that? Counsel for plaintiff.
No, Your Honor.
Counsel for defense.
No, Your Honor.
Counsel for Hanna. Anybody else who's not been heard on that? Anything needed? I see some negatory nods. I'm not seeing anybody seeing anything or needing anything. Then what I'm going to do is I'm going to wish you all a great rest of your day, rest of your week. Hopefully you enjoyed the snow, or if maybe the snow was not too impacting things that you needed to do. Have a great one, and we are moving on to the rest of our calendar. Thank you so very much.
You as well, Your Honor. Thank you.